Good evening, everyone. We'll just start in a couple of minutes. If everyone could please have a seat. There are a couple of empty rows at the back. Um, I- Good evening, everyone. My name is Sunitra, and I lead the legal design and regulation team at Vidhi Centre for Legal Policy. Thank you so much for coming to our event this evening. We're very excited to have you. Our event is called Making the Law SARAL. And we are especially excited to have all of you with us because this is a topic that attempts to bridge the gap between lawyers and non-lawyers. So we are all agreed that legal documents are very complex, they're difficult to understand, and often they create barriers to citizens who are trying to access their rights and obligations and understand their obligations. So to address this challenge, we at the Vidhi Centre for Legal Policy have incubated the SARAL Initiative, which is a pioneering effort to make legal documents in India simple, accessible, rational, and actionable. However, this requires no introduction, but the highlight of this event is, of course, the stellar panel that we have with us. And this panel is exceptional, sorry, because they have all individually, as lawyers, recognized that laws, judgments, and legal documents are written very densely and incomprehensibly. And this does a distinct disservice to the persons who must interact with them and who are governed by them. So these are always the ordinary people who are affected, and complex laws and the inability to understand them leads to barriers to access to justice and high financial costs. I'll stop here and I'll introduce our speakers. We have Justice Chandrachud, former Chief Justice of India, who will also be our keynote speaker for this evening. He has been instrumental in delivering several landmark judgments of this decade. Justice Chandrachud has also himself been a proponent of plain language in legal drafting, calling for simply drafted judgments and stating that the purpose of judicial writing is not to confuse or to confound the readers beneath the veneer of complex language. He's also stated often that a judgment must make sense to those whose lives and affairs are affected by the outcome of the case. Thank you, sir, very much for joining us at this event. Next, I would like to introduce Justice Gautam Patel, who is a former judge in the Bombay High Court. He is well known for his incisive, witty, and well-constructed judgments. He's also been a keen champion of simple legal drafting without the use of any unnecessary jargons or legal maxims. In several past conversations that we have had, he shared some of his pet peeves while drafting, which specifically include the use of the term and or, which I think as lawyers we are all guilty of using at some point. Thank you, sir, for joining us. Next, I'd like to introduce Mr. Jyoti Sagar, who is the founder and chairperson emeritus of J. Sagar Associates and KNS Partners. He has been a passionate advocate of the use of plain English by the legal community and has conducted several seminars, awareness programs, and has written numerous articles for the promotion of the use of plain language. In addition to this, we at Vidhi and we at Saral have the distinct honor of Mr. Sagar being our mentor and patron and guiding all our work within this SARAL initiative. His courage of conviction that any legal document, no matter how complex, can be made simple has given us confidence in our work and has helped us expand our vision much beyond what we had initially set out to do. Thank you, Mrs. Sagar, for joining us. And finally, we have Ms. Julie Clement, who will be joining us online from Michigan. I'll just give a moment so that she can join us on screen. Good morning, Ms. Clement, for you. Good evening for us. But Ms. Clement is a legal writing and plain language consultant based out of Michigan. She is the president of Clarity, which is an international organization promoting plain legal language to engage and empower citizens around the world. She's also on the Center for Plain Language and the International Plain Language Federation boards. She is, in addition to all of this, she is also deputy clerk with the Michigan Supreme Court. She is currently working on the first international standard for plain language drafting. And in addition to this, she is also a distinguished professor of Emerita of Western Michigan University Cooley Law School, as well as Simon Fraser University. Thank you very much for joining us, Ms. Clement. We are honored to have all of you here with us today. Now, I'd like to invite my colleague Rakshita to introduce all of us to the SARAL Initiative and the work that we do here, as well as to share the key highlights of the SARAL survey report, after which we will invite all our speakers to join us in releasing the report. Thank you.
Thank you, Sunetra, and a very good evening to all of you. And like Sunetra said, a very good morning to Ms. Clement. And thank you for taking out the time to join us today while we launch this report. Now, I just want to introduce you to the SARAL Initiative, which is India's first plain language drafting effort. And why plain language, you ask? Because just last year, the Ministry of Consumer Affairs realized that out of all the consumer complaints that they receive, 1/3 are just from the insurance sector. And many of them arise purely because insurance documents are written in such a convoluted and ambiguous language that people are simply not able to understand them. And if you read through the pamphlets that we've provided you with, you will realize that Cleveland Clinic was able to recover an additional $1 million in payment. Yes, $1 million after patients were finally able to make sense of the billing statements that they were provided with. Now, of course, our speakers tonight will be doing a much deeper dive into this issue, but I wanted to start with one simple point, that the law should be for everyone and that the law should be clear. Now, keeping this in mind, these are the principles that the SARAL initiative is built on, which are simplicity, accessibility, rationality, and actionability. Now, as lawyers, we often draft like we're building a fortress that's meant to protect against all legal risks. But should it not be about the citizen first? And that's the kind of approach we're trying to promote with SARAL, where the citizen comes first and documents become not just simpler to read, but they become actionable and practically usable. Now, which is why our areas of focus are the legislature, the private sector, as well as academic institutions, to make sure that this change ends up impacting all sectors which are of importance and pertinence to the documents that people end up dealing with on a regular basis. And to do this, we create drafting guides, we simplify existing legal documents, and we also train law students in the hope that the future generation will revolutionize the legal system. And I want to quickly take you through an example of the kind of work that we're trying to do with the SARAL initiative and the way in which we end up simplifying language. So if you look at the clause on the screen in front of you, this is an example from the Right to Education Act 2009. And I'll just read it out for you. Where a child above 6 years of age has not been admitted in any school, or though admitted, could not complete his or her elementary education, then he or she shall be admitted in a class appropriate to his or her age, provided that where a child is directly admitted in a class appropriate to his or her age, then he or she shall, in order to be at par with others, have a right to receive special training in such manner and within such time limits as may be prescribed, provided further that a child so admitted to elementary education shall be entitled to free education till completion of elementary education, even after 14 years. Now, if a child has a right to education, that child should not need a lawyer to understand that right, isn't it? But this clause is like a maze. It's long, it's winding, and it's full of he shall, she shall acrobatics. Now, if you look at the clause on the right, this is a more SARAL version that we've tried to prepare. Firstly, we've tried to break it down into multiple subclauses. So each idea is contained succinctly in one clause. You look at the clause and you're able to realize which children have these rights, what are the special kind of training that they're entitled to receive, until what age they're entitled to receive that. Now, this is just a taste of the kind of work we do, and we try to do this across sectors. Now, it's one thing for us to say that legal language is complex and that it should be simplified. But at the same time, we didn't just want to assume that that is the case. We wanted to hear from the very people who use these legal documents. So we asked them, which is why we conducted India's first public survey to tap into the need to simplify legal documents. And we wanted to ask the people, what issues do they face with these documents? Are they able to understand them? Where exactly do they get stuck? Do they feel like the law empowers them, or does it not? And which is why we reached out to the people. Now, of course, surveys of this kind have been conducted in other countries, but India is a whole different ballgame. Here, many factors like your gender, your age, the language you speak, your caste, whether or not you've ever held a legal document in your hands, all of these factors end up impacting whether you understand legal documents or not, which is why the survey. Because we wanted to reach as wide a demographic as possible, we conducted the survey across socio-economic groups in 3 locations: Delhi, Bengaluru, and the NCR, including areas like Ghaziabad. And in all, we were able to hear from about 600 people, including both the general public members and legal professionals. Out of these 360 general public members and 40 legal professionals answered structured questionnaires for us so that we could take away some statistical data points. But at the same time, numbers sometimes don't present a full enough picture. So we also wanted to sit down with people and understand what they think. So we did 18 focus group discussions with members of the general public. And we often think that it's lawyers who are standing in the way of legalese being done away with, and that there's going to be a lot of resistance from within the legal community when we talk about simplifying legal documents. So we also spoke to 24 legal professionals, and we did in-depth interviews with them because we wanted to understand what they have to say about this. And we'd also like to thank CMSR consultants who helped us carry out the survey in a very smooth manner and help us reach all these people. Because we wanted to cover the entire spectrum of legal documents that a person ends up dealing with in the course of their life. We looked at a rent agreement, we looked at excerpts from the RTE Act, and we looked at excerpts from a judgment. We presented people with 2 versions of these documents, a standard version and a SARAL version, and we asked them to compare them on the basis of certain metrics. Now here's the catch, we didn't tell them beforehand which version was which. Now, before I move on to the findings from the survey, I just wanted to share that we knew that legal documents were a challenge for people, but we weren't ready for how deeply people engaged with this issue. They shared their personal struggles, they shared their frustrations, they even shared ideas for change. And this is when we realized that this is not something that exists on just paper. This is not something abstract. This is something real that affects people in a very real way. Now, when we presented people with these documents, we asked them to compare them on the basis of 3 metrics. The first big question was that are both the documents as credible and do people see them as legally valid? Now, most people agreed with us. In fact, most people ended up saying that both documents are valid legal documents for them. And some people even said that they, in fact, found the SARAL version more credible because they could trust it more, because they understood it better. And this goes on to tell us that the credibility and validity of a legal document in no way depends on the use of legalese or traditional legal language. Now, coming to the second part, the ability to understand these documents. And here, the SARAL version won hands down. Both general public members as well as legal professionals agreed that the SARAL version was easier to understand because of simple language, as well as a more structured format. And people even shared tips to further simplify these documents with us. Now, at this point, you may be thinking that, okay, fine, these documents are simpler, they're easier to understand, but are they legally sound? And over here also, the answer was a yes. The legal professionals that we surveyed found both the standard and SARAL versions to be legally precise and accurate. And this goes on to show us that once again, even simple language is perfectly capable of communicating technical legal concepts, and there's no barrier in that regard. Now, if you have ever struggled to understand legal documents, you're not alone, because our survey showed us that a whopping 84.5% of the people we surveyed said that they struggle to understand legal documents. They're hardly ever able to make sense of them. And it didn't just stop at that. People shared a lot of stories where the complexity of legal documents had affected them personally. For example, a focus group discussion participant from Ghaziabad shared how he was once embroiled in a property law dispute. And there was a court order that he wasn't able to understand. So he ended up relying on his lawyer, like many people do. And turns out he shouldn't have, because the lawyer misled him. And the lawyer colluded with the opposing party to fleece him of a lot of money. And this is supported by what people said during the survey as well. 73% of the people said that complex legal documents prevented them from exercising their legal rights. It doesn't just stop at that. There were many negative consequences attached to this. For example, another focus group discussion participant from Harinagar shared how she was once supposed to go on a trip, and she booked this trip through a travel company. Now, the trip got cancelled, but the travel company didn't issue her a refund. And the travel company was the one who cancelled the trip, by the way. And turns out there was a hidden clause in the agreement that she had signed, which said that there would be no refund in case of a cancellation, but she never got to reading it and understanding it. And finally, she had to bear that financial loss. And this is exactly what people in the survey said also. 61% had faced some or the other negative consequence, from financial loss to actually having to face legal action because they didn't understand their rights. And what did all this lead to? Mistrust in the legal system. 74% of the people said that because of complex legal documents, they don't trust the legal system anymore, and they're extremely wary of any kind of legal recourse. Now, because change has to come from within, change has to come from the lawyers themselves, we also asked lawyers what they think about these documents. And 70% of the lawyers we surveyed also agreed that legal documents, in fact, are often very confusing. They're very ambiguous. And they also admitted that forget the general public, even lawyers have to read documents multiple times, a lot of times, in fact, to be able to make head or tail of them. So if lawyers can't understand, how do you expect a general public member to? And 85% of the lawyers we surveyed also believe that simplifying legal documents is crucial to make sure that they become accessible to the average citizen in this country. Now, the question we ask is that the people clearly want simple legal documents. And from what we can see, even lawyers are not opposed to it. In fact, many actively support it. Then what exactly is stopping us from making our legal language accessible? Now, if we have to bring about a change, we have to do something about it. The first most obvious step is to actually simplify legal language. We have to minimize legal jargon. We have to structure our documents more clearly. And we have to make sure that people can understand them without possessing a legal degree. And sometimes even after possessing one. And this is something that can't be achieved alone. This is something for which we need a movement. So I'll take one example. In the late 1970s, there was this movement being run in England called the Plain English Campaign. The members of the Plain English Campaign got together and they shredded thousands of government forms in Parliament Square, London. The result of this was that this got significant media attention. There was outpouring of public support. And finally, government agencies did feel compelled to make changes and to adopt protocols for clearer communication. Now, if they can do it, we can as well. And finally, simplifying legal documents is the key to making sure that we can ensure access to justice for the people and that we create a legal system that people can trust. So we have the demand, we have the support, and now it's time to take action. And the law belongs to the people, and we should make sure that they can understand it. And with this, I come to the close of this presentation. And I would like to invite our panelists and Justice Chandrachud and the SARAL team to launch the SARAL report.
Thank you very much, Rakshita and the whole team. You've done incredible work in putting this survey and report together. And now, without any further ado, this is the moment that we've been waiting for. Chief Justice Chandrachud is here. He's been a role model for many of us, not only those who work on simplification, but those who believe in the rule of law in the country. I also have a personal connection. I used to be his law clerk in the Bombay High Court back in the day in 2004 for a very short period. And from then on, I've seen and marveled at Justice Chandrachud's passion for simplification, not just in what he says, but also in what he does. So without any further ado, I would like to invite Chief Justice Chandrachud to give his keynote lecture. Justice Patel and Mr. Sagar, we've got some seats there. You can take that. Justice Chandrachud, over to you.
Good evening, Dr. Argo Sengupta, my very good friend, Justice Gautam Patel, Mr. Jyoti Sagar, the SARAL team, whom I must compliment at the outset, and everyone present here who desires simplification as the mantra of life. I'm delighted to be here for the release of the survey report of the Simple, Accessible, Rational, and Actionable SARAL team. When I was invited for this event, I pondered on how the criticism of complex legal language and support for plain language is universal. Very few would seriously argue with the merits of simple legal language, but we have found it oddly difficult to make progress on it. There's a well-known saying that the law is a language of reason. Yet for the average citizen, the language of the law often appears anything but reasonable. And we just saw some examples of that in the introductory presentation. The language of the law is cloaked in complexity, burdened with archaic phrases, and remains largely inaccessible to those it seeks to serve. Let me illustrate this with an anecdote. A junior lawyer was once tasked with drafting a rent agreement requiring the tenant to undertake repairs of the premises. Eager to be precise, the junior wrote, "The tenant shall repair the premises." His senior or her senior took one look at the draft, sighed, and replaced it with the following words: "The tenant shall, when, where, and so often as occasion requires, well and sufficiently repair, renew, rebuild, uphold, support, sustain, maintain, pave, purge, scar, cleanse, glaze, empty, amend, and keep the premises in every part thereof, including all floors, walls, columns, roofs, canopies, lifts, escalators, shafts, stairways, fences, pavements, forecourts, drains, sewers, ducts, flues, conduits, wires, cables, gutters, soil and other pipes, tanks, cisterns, pumps, and other water and sanitary apparatus thereon, with all needful and necessary amendments whatsoever." When I read this, it didn't appear to be extraordinarily daunting, because I've come across these illustrations repeatedly through a legal and judicial career. The anecdote reveals two enduring tendencies in legal drafting. First, the penchant for using many words where one would suffice. And second, an obsession with precision that paradoxically creates more ambiguity. Both these tendencies are remnants of a time when the law was the exclusive domain of intellectuals and was deliberately kept inaccessible to the layperson. Jeremy Bentham observed, "Lawyers employed stilted, redundant, and overly formal prose to create the illusion that legal drafting is far more complex than it really is. Were legal documents stripped of their unnecessary jargon, Every simpleton, he said, every simpleton is ready to say, what is there in all that? This is just what I should have done myself. The use of jargons and complexification of legal language comes also from the fact that the law has developed primarily through text. The common law tradition of precedent has attached a degree of sanctity to earlier judgments. Once a complex phrase enters the legal vocabulary, it is difficult to simplify or undo it. Legislative language sometimes outcompetes judicial language for complexity. Sometimes it reflects the deliberate intention of the drafters to remain ambiguous. And sometimes I fear people just do not know what to say and therefore rely on outdated boilerplate phrases. Morality or custom may be embedded in human behavior, but legal discourse by definition comes into being through language. Thus, the legal profession focuses intensely on the words that constitute the discourse, whether in the form of statutes, regulations, or judicial opinions. It is fraught with intricate constructions of double and triple negatives, different types of if clauses hypotheses, piling, exceptions, reservations, declarations, and so on. What these do is to impart exact illocutionary force to legal norms. It is principally this grammar which creates the mind-boggling effect of so many passages in legal discourse. Well, one could argue that had the law developed through oral advocacy, it would be simpler. After all, the lawyers who use incomprehensible language in documents are able to speak just fine when approached verbally. Because law developed through the handing power of words in text, it attained a form of rigidity. Successive generations of lawyers adopted it for fear of being misunderstood if they stray too far off the tried and tested lingual norm. Lawyers continue to reach for familiar words or phrases out of habit, without pondering whether the words contribute anything to the meaning that they hope to convey. Much of this is boilerplate, which one never deletes. But legal discourse is not inherently verbose or compact. The incentives under which lawyers operate make all the difference. Lawyers who draft private documents like contracts, deeds, and wills are normally paid by the hour and may feel a need to impress their clients or justify their fees with the length and complexity of their prose. They would naturally be inclined to make liberal use of redundancy and a verbose style. But there are also times when the jargon of legal language serves an intended purpose, either by affording a general sense of legal flexibility or by compressing an idea into a word. For example, the reasonable man test gives a wide latitude of flexibility in deciding what could be reasonable. The term and its malleable meaning addresses the rapidly evolving measures of reasonableness in society. What may have been reasonable yesterday has changed today and will further change tomorrow. The legal test of reasonability, therefore, requires a judge to consider the position of the party and make an assessment of their actions in line with contemporary practice. On the other hand, legal terms may capture a broader idea. For instance, cypress, despite being an obscure word borrowed from Norman French, captures the legal doctrine that allows courts to modify the terms of a legal document to achieve the original intent of the draftspersons. The problem is that since lawyers have seen these specialized terms develop through an evolution of complex legal discourse, they fear that the evolution would stop if they simplify the nature of legal discourse. The result is that the legal language we now have is full of relics from the past, with obsolete English words and grammatical constructions, as well as outdated French and Latin terms. As recently as in August 2022, the Supreme Court had to point out the incomprehensibility of legal language. I remember a case which came to us where we struggled to make sense of the language in the judgment of the High Court. While remanding the case back to the High Court, we remarked that the purpose of judicial writing is not to confuse the reader behind the veneer of complex language. The purpose of the law is to simplify the decision-making avenues for the litigant. When a litigant untrained in the methods of law is confronted with an incomprehensible document or judgment, it not only denies the litigant the right to make sense of what will materially impact them, it also affronts the dignity of the judicial institution for making itself inaccessible. Criticism of lawyers' writing is not new, however. In 1596, an English chancellor decided to make an example of a particularly prolix document filed in his court. The chancellor first ordered a hole cut through the center of the document, all 120 pages of the document. Then he ordered that the person who wrote it should have his head stuffed through the hole and then led around to be exhibited to all those attending court at Westminster Hall. The old English chancellor may have been the Robin Hood of litigants in today's age, rescuing unassuming citizens from the leviathan like legal discourse of the lawyers. Thomas Jefferson, the author of the American Declaration of Independence and the third president of the United States, stated that from their lawyers' verbosity, their endless tautologies, their convolutions of case within case and parenthesis within parenthesis, and their multiplied efforts at certainty by saids and aforesaids, by ors and by ands, to make them more plain, do really render them more perplexed and incomprehensible, not only to common readers, but to lawyers themselves. The obscurity of the law creates spheres of influences in society. Those who draft and understand the law occupy the largest sphere. The bureaucrats and office bearers who can pretend to understand legal language occupy the secondary spheres. Unfortunately, a common citizen, innocent of the vagaries of legal language, is left in the periphery of this zone of influence. This is fundamentally at odds with the purpose of the law, least of all in a democratic society premised on absorbing legitimacy and power from the citizens. The exclusivity of legal language produces marginalization and excludes the already marginalized. Whatever the original intent of complex legal language may have been, it now breeds intimidation and overawes its primary constituent, namely the citizen. Almost all of us have skipped over privacy terms, lease agreements, and several boilerplate clauses in commercial contracts. The complexification of legal language has created a scared citizenry who feel that the law, if out of reach for their understanding, is really not a law meant for them. In the face of desperation and confusion, an innocuous litigant is badgered with the Latin maxim, ignorantia juris non excusat, or the ignorance of law is no excuse. The spheres of influence and marginalization of legal language are fundamentally incompatible with a people-oriented legal regime. In a democratic setup, law must be accessible to its subjects. The rule of law postulates within it the transparency and wide publicity of the law. Little does publicity help if the language of the law is convoluted and disorienting. The SARAL survey, which we released today, is based on broad interviews with members of the legal fraternity as well as non-lawyers. Over 98% of the respondents believed that legal documents must be simplified. 74% of legal professionals said that legal language can be ambiguous, and 91% of professionals identified the need for simplified legal discourse. The general antipathy to legal language among citizens and lawyers must be enough to move the needle on simplification of legal language. I, of course, understand the importance of language, which has attained a larger legal connotation and may therefore be difficult to replace. When the framers of our Constitution were discussing draft Article 301F, which later became Article 348 of the Constitution, relating to the languages of the Supreme Court and the High Courts, they settled on English as the official language of our constitutional courts. Two reasons animated their move. First, judgments and language of constitutional courts had acquired a specialized discursive role in the legal system. It marked uniformity and would avoid unnecessary misunderstandings and loss in translation. The second reason was a degree of unification among constitutional courts in India, where judges not belonging to a certain state may nevertheless occupy a seat on its high court. With this paradox of universal regard and universal disgust of legal language, we have maintained an inflexible, rigid, and archaic body of legal language. But the need for specialization of legal language has hardly served its purpose. In a recent case, which I had the opportunity to hear, a constitution bench of the Supreme Court was deciding whether the power to regulate industrial alcohol belonged to the state or the union legislatures. Entry 8 of the state list of the 7 scheduled states that intoxicating liquors, that is to say, the production, manufacture, possession, transport, purchase, and sale of intoxicating liquors. On a simple reading, it seems that entry 8 of list 2 only governs intoxicating liquors or potable alcohol, which one would normally consume orally. But when one traces the evolution of the entry from the Abkari laws in colonial times, we found that the term liquor was coterminous with any liquid. So your liquor in the coffee liquor. The archaic use of the word liquor to mean liquid led to 34 years of uncertainty because of the Supreme Court, in a 1990 judgment, read the word liquor in its contemporary sense as opposed to its intended meaning. For 34 years, the union and the states were stuck in a game of Russian roulette. Usually the same establishment may manufacture potable alcohol and then add disagreeable substances to it for industrial purposes. The same establishment would therefore fall under state and union regulation at different stages, leading to a commercial chaos for manufacturers. Far from being precise, the legalized term liquor created widespread uncertainty in the market and the power of governments to levy a tax or fee. Moreover, language creates an ecosystem of social values which may be perilous for being inflexible. In October last year, we were dealing with a case of a medical aspirant with 88% lower limb myopathy who was declared ineligible for a medical degree course on the ground that his disability would hinder course completion and patient safety. After a reassessment, we found the candidate to be perfectly suitable for the medical course. To adjudicate the matter, we looked at the erstwhile Medical Council of India's committee report, which recommended the standards for disqualifying persons with disability from medical courses. I found the language used in that report was highly ableist. Besides making archaic observations requiring persons with disabilities to, into invert commas, introspect and assess themselves whether they are likely to meet MCI standards and outcomes. The report also declared that it would not follow reasonable accommodation mandates because they may lower the standards of medical practice. The report perpetuated an ableist mentality. It reified the idea that persons with disabilities are an active hindrance to the medical profession and their admission must be microscopically monitored. The language of the report translated to legal attitudes towards medical aspirants with disability who would frequently be denied admission. It also translated to some judicial opinions which failed to catch the evil of improper language affecting the fundamental rights of persons with disabilities. In that case, we therefore held that when it comes to rights, language matters. Words may not always adequately reflect the intention of the drafter. Some words may be used unwittingly, without knowledge of its harmful consequences. Nevertheless, these words influence the thinking of others who hear them. The judgment continued to opine that words are the tools one deploys to formulate thoughts. An expansive vocabulary allows people to think and articulate their thoughts better. When we use appropriate and sensitive language, we aspire for the quality of our thought to be broadened and evolve towards being emancipatory and inclusive. Legal language, far from being SARAL, imposes its own current of moralistic influences. Further examples of this are Section 377 of the Indian Penal Code, the erstwhile Penal Code of 1860, which moralistically deemed non-peno-vaginal sexual acts as unnatural acts against the order of nature. Or Sections 375 and 376 of the IPC, which even in their new form of Section 63 and 64 of the Bharatiya Nyaya Sanhita, uses the word rape, which originally meant to snatch, to grab, to carry off the property of a man. Both these provisions impose a social morality to the legal crimes they seek to address. In fact, Section 377 of the IPC was not even afforded a discussion during its drafting stage because Lord Macaulay did not want to provoke indecent public discourse and unwittingly lend credibility to discourse around homosexuality. This legal constructionism has led to deliberately moralistic and archaic language to grow. In 2023, the Supreme Court of India released a handbook on combating gender stereotypes. It identified widely used legal phrases like career woman, chaste woman, and woman of easy virtue, which not only complicate language, but impose a sexist ideology to the law. These words were replaced with a simple word, woman, an attribute strictly necessary for legal purposes. The wrongdoing of words like career woman, chaste woman, and woman of easy virtue was not purely moralistic. It also injected different legal standards premised on the immorality of these women, which ought to be relevant in a liberal democracy. So when you call a woman a career woman, you're basically saying that, well, she's only interested in furthering her career. Completely incorrect. A career has nothing to do with how you would look after your aged parents or your children or your grandparents or your friends in society. So basically, another word the handbook sought to replace was the word prostitute, which was replaced with sex workers. The word in the handbook carries a footnote, which states that the word prostitute may be used when required in the context of the Immoral Traffic Prevention Act 1956 or any other legislation. This footnote I added after we received emails from several activists in the field who said that, look, this word has been used in the statute itself. So it was added a month after the release of the handbook in August 2023, because we realized that despite its regressive connotation, Parliament had codified the word and it could not be changed by a humble handbook. Simplification of legal language is not a mechanical exercise. As I said earlier, law has developed through texts. It is the economy one transacts in for legal purposes. But language is not devoid of social and political contexts. Simplification must necessarily include progressive connotation of moving the ideology behind legal language. Legal language has the effect of moralizing and certifying the validity of thought processes. If our language is regressive, it lends credibility to discrimination. If we can simplify legal language while making it inclusive, we can realistically affect change in perspectives. This is a democratic dividend. Law must be accessible in all senses of the term. It must be accessible in terms of comprehension and in terms of inclusive or exclusive effects it has on legal subjects. The point I'm trying to make through these examples, old and new, is that law has a commanding effect. Simplification of legal language also simplifies compliance. But simplification cannot be done in socially agnostic environments. Even if the drafter is unwilling, they must deploy moral weapons in legal drafting. The painstaking task of simplification is therefore both tedious and socially deliberate. The work of the SARAL team is a step in the right direction, ensuring that the law speaks not only the language of reason, but also the language of the people it serves. But above all, the law must speak the language of a society we want to evolve for a good society in the future. To achieve this goal, we must advocate for legal reforms that promote clarity in legislation and judicial opinions. Law schools should emphasize plain language drafting in their curricula, ensuring that the future generations of lawyers internalize the principles of accessible legal writing. Courts must take a proactive role in interpreting statutes in ways that prioritize clarity over unnecessary complexity. We must also recognize the role of technology in democratizing legal language. Legal tech platforms, artificial intelligence-driven contract analysis, and online repositories of simplified legal documents can serve as invaluable tools in bridging the gap between the law and the people it governs. Legal practitioners and policymakers must harness these advancements to create a legal system that is transparent, fair, and accessible to all. With large language models, or LLMs, in generative AI, the legal profession is eminently staring at a revolution. In many areas of the legal profession, AI has already changed the way one works. With time, I assume that AI will be used to automate drafting of boilerplate clauses, create first drafts of written submissions, and index case law compilations. It has been demonstrated that generative AIs are changing our language by deploying words which had either phased out of common speech or were uncommon to begin with. The change in language which AI has introduced must illuminate us to deliberately harness it for simplification. If we are able to train AIs which are required or used for legal drafting to simplify language and flag areas of concerns where a certain word has been judicially interpreted, we can accelerate our processes of simplification significantly. On a personal note, I'm deeply concerned with the fact that when I pen an email, my AI software is constantly telling me what to replace my language with. But what happens is that the quirky me now tends to become a stereotypical average letter writer writing correct English. I accept the correct English, but realize that I'm losing my personality in the emails which I write. But the moral of the story is that this can be achieved. Just one last example before I'm done. Look at what has happened to the Income Tax Act of 1961 when the new bill was introduced in Parliament. The number of chapters, 47, down to 23. The number of sections, 819 in the original act, down to 536. The number of words, 5.12 lakhs, down to 2.60 lakhs. 1,200 provisos and 900 explanations have been removed. Alphabetical suffixes, including section 10A and section 35, capital A, capital B, which flummoxed judges and litigants, but was a paradise for lawyers, again removed. You know, there's been a project at the National Law School of India, University in Delhi, called the Feminist Judgments Project, which tried to give to society an alternate construction of judgments written in a feminist style, devoid of patriarchal assumptions and prejudices. I believe we need to start some project of that nature, pick out random judgments, and have not the Feminist Judgments Project here, which is already underway, but the Simple Judgments Project, which means that we have to train students in law schools. We have to also train lawyers who engage in regional language lawyering, because we must understand that the district judiciary today is manned by lawyers who speak regional languages. And too often we translate from English into regional languages. So unless we make the law simplified for them, it would be difficult. Finally, just a word on simplified pleadings. It's important that we move towards mandatory fields for eliciting the essence of a case. Why leave the entire format of a writ petition to a lawyer who would have grounds going up to ZZZ or ZZZAB? Mandatory fields which will elicit the essence of a case. But this will require a change from a lawyer-driven legal profession to a justice-centric legal profession. Let's face it, we are a lawyer-driven legal profession, and we need to answer that at its fundamentals. Complexity, and that's my only little caveat on the SARAL survey. Lawyers have supported simplification, but let's face it, complexity favors those who want to delay or defeat justice. So very often when you wanted to conclude an argument early, the lawyer would tell you that I'm going to take 3 days of time. And so very often you had to give up a case just because you knew that the assignment was changing and you were aware of the fact that someone was trying to delay or defeat justice. So complexity favors the resourced and defeats the cause of justice or those who are in need of justice. And I think we have to generate templates. In one of the PILs which I dealt with as the Chief Justice of India, we tried to develop a template for apartment buyer agreements across the country. And we said, why can't we have one common template for ABAs, as they are called, across the country? Well, there may be regional divergences, such as the slum rehabilitation scheme in Mumbai, but surely you can have essential clauses which will be the same. It took over a year to achieve that, but the process is underway. So I'll then conclude by saying that as we move forward, let us reaffirm our commitment to ensuring that the law does not remain an enigma reserved for a select few. It must be a living instrument of justice, comprehensible to every individual it seeks to serve. Together, through deliberate action, we can make the law not only a language of reason, but a language of the people. There is now little to no meaningful defense for retaining legal language in its current complex and incomprehensible format. It is time that we retire the where-offs and where-enders and the under-the-hand and seal-off declarations and focus on cutting-edge precision in our legal language. I hope the work which Vidhi has been doing attains more seriousness and influence to comprehensively lay out a roadmap for legal language accessibility. I compliment Vidhi and everyone associated with this endeavor. After all, the endurance of the legal system may just depend upon it. Thank you.
Thank you so much, Justice Chandrachud. There was a lot there. But one key line which I'm going to go away with is when it comes to rights, language matters. And I think that this is something that we felt in while we were doing these surveys, that people strongly feel that they want to understand what it is that governs them, but they can't do it. We've heard that helplessness, and I think we saw echoes of that in what you said today. So thank you very much for saying what you did and for doing what you do. And I think there are three broad buckets that you highlighted. That is complexity in laws, complexity in contracts and terms and conditions and privacy policies, and complexity in judgments and pleadings. And we've got a great panel to have this discussion with. So I'm going to take some of this to Gautam first, who has done quite a lot of work in this regard, including writing some judgments on why we need to have simple laws. So Gautam, the question to you would be that I think we can all agree that complexity favors, as Justice Chandrachud said, complexity defeats justice. And as our respondents said, and it's an interesting data point, that 77% of respondents said that complexity favors the wealthy and the rich. So how do we move ahead in simplifying laws, contracts, judgments, and pleadings?
All right, let's take all three of these. As Justice Chandrachud will tell you, I'm known for many things, not all of them flattering. Patience is not one of them, and I have a great deal of impatience when it comes to woolly language and badly phrased sentences. This is actually infectious because its bad language has carried forward into corporate speak as well. There's a very interesting little email where this is known as jargon monoxide. Let me just read you this little bit. It's quite delightful. It says there's a silent killer in your company, and it's not competition, bad hires, or even a broken business model. It's jargon monoxide, a steady stream of meaningless corporate gibberish that seeps into meetings, emails, and strategy decks, suffocating clear thinking and real action. There is the executive who insists we need to leverage cross-functional synergies to enhance stakeholder engagement. The consultant who claims our approach is to drive transformational outcomes via customer-centric innovations. Translations, nobody knows what they're talking about. Jargon monoxide is what happens when people prioritize something smart over being smart. It's corporate carbon monoxide, odorless, invisible, and quietly poisoning your company's ability to think clearly and execute fast. It starts with one person trying to sound more competent than they are. Instead of saying we need to sell more, they say we must drive top-line revenue expansion by leveraging omni-channel opportunities. It goes on like this. You'll find this in law. I don't want to talk about judgments because I honestly believe telling judges that they don't write well is going to meet with resistance. But I do have something to say about the kind of pleadings, as Justice Chandrachud pointed out. And one of my biggest problems is that some of the forms that we have accepted and carried forward with this are actually not citizen-centric. The language, the vocabulary is against rights of citizens. A citizen, my view, should not have to come to court to pray for relief from a court. He is entitled to seek relief. That's the citizen's right. The idea of praying in court is, to my mind, antithetical. And it is not disrespectful to say the petitioner respectfully seeks instead of saying the petitioner humbly prays. There's a qualitative difference in these two approaches. Supreme Court has, for the longest time, and I don't know how it got in there, this absurd phrase at the end of every petition. And for this act of kindness, the petitioner shall, as in duty bound, ever pray. It's not an act of kindness. No, I'm serious. It's not an act of kindness. This is not a ruler dispensing this whimsically. Judges are doing a very serious job applying the law to facts, the statute. You cannot use language like this. You don't need to use it. And why should a citizen be praying for an act of kindness? I just do not get this. This is clutter. This gets in the way. And it leads to us believing that this is the only way to do this thing. And it's not. It really is not. We need to simplify this. Let me give you an example of what happens in the second bucket, which is bad drafting, or third, bad drafting of contracts. This is actually from a December 2024 judgment of the Supreme Court. It's not about the judgment itself, but it's about the clause that the Supreme Court, Justice Oak's bench, identified as being the one that it needed to interpret. Do we have a copy of that?
Yeah, I think they're just going to put it up. Can you put up a copy of that judgment? So while
It's a commercial contract dealing with mortgages and issues under the Insolvency and Bankruptcy Code. Just give it half a minute. All right, let me tell you that. I'll come back to that. I'll come back to that. And contracts. Now, let's take three types of contracts, which I'm taking the most commonplace ones. A rental agreement. At some point or the other, whether it's for an office or a home, leave and license, all of us have to do this. Do we need something that goes into 25 pages when it can be said in 2.5? Powers of attorney. A general power of attorney. Everybody uses this. In Bombay, at least, the average length of a general power of attorney, which begins with all to whom these presents shall come. What does that mean? I mean, if you asked me to translate this, I couldn't. Who are these people who are giving these presents to, and why are you giving them presents? Unfortunately, this is something that can be said in 2 pages. And it does not need to go in like this.
So this is the clause.
Okay, now this is the clause that the Supreme Court identified. In the event that an event of default has occurred under a facility document, the security trustee or its nominee shall, on receiving instructions from the secured benefit, this goes on for a page and a half. This is the hapless. Look, imagine what happens to a Supreme Court judge in the middle of a day when he gets confronted with this. It's bad enough having to work there. I think it's a human rights violation. The amount of work that's flung at them. And then this. And then all of this goes on. There isn't a full stop in this till about 3/4 of the way down. Indian lawyers have this terror of the full stop. I keep telling them, short sentences, full stop. Try it, full stop. It works, full stop.
So maybe, Gautam, I'll interrupt you for a minute and take one point to Justice Chandrachud before I come back to you for the third bucket, which is this point about, the last line in any pleading in the Supreme Court, that for this act of kindness, it is humbly prayed. And do you think this will change anytime in the future?
Well, of course, I think there's no doubt about it that this has to change. The whole template of the pleading has to be modern, simplified, and very easy to comprehend. The legal language of discourse has to change. Namely, you have to do away with his lordship and everything that is said in court as well in the oral form, which is a colonial hangover.
And that one is on the lawyers, because I know the Supreme Court passed a resolution long back that you can call judges of the Supreme Court sir, but no one does it.
And, a lot of the burden must also lie with the judges. For instance, a simple thing that, you can do in judgments, when I would extract or paraphrase what is sought by the litigant before the Supreme Court, I would never say in my judgment that the petitioner has prayed for the following reliefs. All that you have to say is seeks the following reliefs or claims the following reliefs. But I think just greater publicity, the bringing a degree of public awareness to this. I guess the reason why that last sentence has not been removed is that it's inconsequential, in the sense that nobody bothers about it. And it does make a difference. But I think bringing this discourse to the public domain would really result in the attention of lawyers, of judges being brought to this, and changing the whole language of the discourse. It's not about one sentence. It's about it symbolizes the complexity of the law, placing the law beyond the reach of common citizens. Actually, the law should be so simple that you don't need a lawyer to present a case to the Supreme Court. And that should be the aspiration, which is not, of course, to do away with lawyers, but to make it as simple as possible.
That's right. So someone who has done this work for a number of decades is Julie Clement, and Julie joins us. She is president of Clarity International, which is an organization that is dedicated to plain language and has been developing an ISO standard on plain language. So Julie, could you tell us a little bit about your experience globally in trying to ensure that legal documents are simple and written in plain language that everyone can understand?
Sure. And thank you very much for having me. I'm enjoying this immensely, hearing all of these, so much embrace of plain language, which, as we all know, is what people are entitled to. In fact, we had an international conference during the COVID years called Access for All. Plain language is a civil right. And we truly believe that people have the right to understand what is expected of them, to not only their rights, but what's expected of them as well. And if they can't, then they have no rights. And we can't expect them to carry out those responsibilities. So I've been involved in Clarity, which is an international organization for plain legal language that's been around since 1982, I think, or 83. I don't remember. We just celebrated our 40th year anniversary. This is a group of lawyers who started in the UK, just getting together to talk about how can we write better so that people understand. It has grown. There are now the three largest organizations are Clarity, the Plain Language Association International, and the North American Center for Plain Language. We have come together, this is quite a few years ago, to start professionalizing the field, and the ISO standard that was released in 2023, which is the first international standard for plain language, was a huge goal since, I think, like 2009 is when we first set out some of those goals. We have a definition of plain language that is embedded in that ISO standard. That part 2 of the ISO standard is in progress, which is for legal communication specifically. So I'm especially excited about that. I've been the project director for that part, and we are, when I say we're nearing completion, ISO works very slowly, so that doesn't mean it's coming out next week, but we're in the last stages, and we just got back the last almost 200 comments from other experts around the world. So we will address those next. It really has been a movement for 40 years or more, and we're really starting to see some changes, which is exciting. You know, some of the things that both of the justices, I say this morning, it's morning here, have already talked about, is this, you know, this adherence to this language that this is the way we've always done it, and yet the people that we are trying to reach don't understand it. What I find really interesting about that is that lawyers often say that the law is too complex. We lose precision when we use plain language, which of course we know is a myth. But if that's the case, I mean, just taking that argument one step further, if that's the case, then somebody always needs to explain that complex, you know, that complexity to someone. And then what are you risking? Okay, if people can't understand it when they read it, they have to go to someone to explain it to them. What if that person gets it wrong? What if they get explanations from 3 or 4 people and each one has a little bit different explanation? I mean, this just illustrates that it's not too complex. We just have to explain it well, and so that everybody can understand it. So I don't know if that answered your question, or
I think it does.
About.
Yeah, no, I think it does. And I think this is one of the biggest myths that we find, which is that difficult language is necessary for precision. And I think what you've said really hits the nail on the head, that if it was so precise, then you really wouldn't have different interpretations on a provision. And I think with language necessarily is imprecise, so it will require lawyers. And I think this is a good time to turn to Mr. Sagar. Mr. Sagar actually has been working on simplification for decades. And Mr. Sagar, I think one of the things that we heard from a lot of our respondents is actually in everyday documents, like bank opening forms. Why is a bank opening form in 29 pages in dense legalese that nobody understands but has to sign on every page, irrespective of whether the bank is promising digitization or not? Everyone still opens bank accounts in the same way. So as far as private documents are concerned, bank opening forms, warranties for products, the privacy policies, the everyday stuff that we deal with, how do you think we can move towards making those simple?
Thank you. First of all, I wanted to say it's very nice to see Julie on the screen. I am the solitary Clarity member in India, and I hope that some of you will join me as being a member of Clarity. So just before I answer that question, to my mind, the question of language actually is just going to the fundamentals, and the fundamentals are language. We use language to communicate thoughts and ideas. So if I am communicating a thought and idea to you in a manner that you do not understand it, then the objective is lost. Now, if we all believed that an act of parliament, a judgment, a pleading, a contract, each one of these is nothing but communication. You're communicating something to the reader or whosoever comes across it and needs it. Now, if you kind of start from that, then the whole idea that your reader needs to understand what you're saying becomes very clear. And as was said by Chief Justice earlier, there was a time when laws concerned intellectuals. In fact, they actually, laws were only meant for the landed gentry, the aristocracy, who had all the rights. The serfs, the normal people on the street had no rights, literally. Today, we all have legal rights, and law touches us in our daily lives 100 times. Now, if the purpose of the law is that you understand what you can and what you cannot do, if you can't understand what's written there, how on earth are you supposed to actually comply? And the question of compliance came as well. Now, the same thing actually applies to every form of legal communication. And I think that the need for simplicity is more important in what I call as L to C communications, lawyers to client or to consumer. I mean, as L to L, lawyer to lawyer. Three of us are sitting here who come from the legal profession, and we can talk in a strange language that only we understand with a secret handshake that, we are all lawyers and we belong to a society. But as far as the consumer is concerned, the consumer needs to understand what her rights are. So it could be a warranty card for a refrigerator that a householder has bought. Now, what that warranty extends to, what does it cover? Or an insurance policy. I'm sure if all of you have, cars, just go down these days, they don't issue the full form insurance policy to you. But when you see the certificate of insurance, it has that thing to say, visit this and this site for the policy that you just bought. Go there and see and figure out what is covered and what is not covered. I can bet my life that, you spoke about 2 or 3 negatives. I have seen insurance policy with quadruple negatives. So by the end of it, you do not know really what is covered and what's not covered. I mean, it's incredible. And same with all forms of insurance policies. And some of them you actually feel, is this really deliberate almost? Because if you read all that, you would never have bought the policy. So that's the proverbial fine print. But the thing here is that for any business, I think it makes sense for the business to make sure that it conveys all the terms and conditions in a very simple form. It can actually become a unique selling proposition. It's a marketing tool to say, I use simple language in all my communication so that you understand your rights and your obligations. So we have seen complex forms. In fact, up to very recently, if you actually read the boarding pass that you have for an aircraft, that was used to be full of legalese. And of course, as you heard, we lawyers use many defenses, and precision is one of them. Is the legal and precise, but actually it isn't, because that won't explain 70 volumes, words and phrases legally defined. And I got interested in one particular word, which we all lawyers, and this room has many lawyers, the word shall. Now, shall is supposed to be a very strong word. It's you have to use it in an Indian. We Indian lawyers use it 3 times in one sentence. And I found that there are over 1,300 judgments from a common law jurisdiction on the word shall. This has been seen to, been interpreted to mean may, should. I mean, it's, you will not believe it. It's supposed to be a strong word. Now, precision, and then again, that there are technical terms. And when you actually do stats, 2 to 3% at max of a contract actually has technical terms. The rest, the term of art. We use a word like mortgage and lease, which most people understand. Those are term of art. But rest of it, what we lawyers pass off is actually jargon, absolute jargon. Now, you heard Gautam talk about know all men by whom these presents shall come. Now we have this in witness whereof the parties hereunto have set their hands. So just saying the parties have signed this document. Or we start by saying, start the, when the agreement starts, now therefore in consideration of the premises aforesaid and representation, warranties, and so on, so on, so on, so on, the parties agree as follows. Now, this can just be replaced by saying the parties agree as follows, because the rest of it is rubbish. It is pretension. We pretend that, my God, to really make it legally effective, we need to say all that. It's not actually true. So most of the law can be conveyed in simple terms, and we are now seeing some companies actually take a step forward and say, how do I simplify my communication to my customer? How do I make their life a little bit simpler? And as we all know, that most of the movements started as consumer movements all over the world for simplification of language. And I think the lack of great consumer movement in this country is I think one of the reasons why this thing hasn't taken off earlier on than what we're trying to do now.
So Justice Chandrachud, what I'm hearing from Mr. Sagar is that this is just the status quo. And what you said in your speech also, that this is 500 years of history, right? The legalese has gone on for centuries. And no, sorry?
1500 years.
1500 years.
We use are from Old English.
I was only saying 500 because you gave that example of that Lord Chancellor, which was in the 16th century. And I think the key thing is that how do we move from here? We've all agreed here that this is just essentially something that has gone on, which has really not, no one has made it their issue. So the question really that arises is that how do we move ahead from here, particularly when it comes to things like contracts? How do we move ahead towards a time where this will be written simply?
The answer really would be to move on simultaneously on different fronts. When you first take the case of pleadings in courts, develop simplified templates for every court, whether it's a suit for breach of contract, whether it's a writ petition before the High Court, whether it's before the Supreme Court. Confine pleadings to strict word limits. If you can't say something within a short frame of, say, 500 words, you probably don't have a case. You just want to make it complex. So you have to proceed at that level. Second, legislative drafting. The real dearth of good legislative draftsmen that stares us in the face, which then highlights the need for the government to induct more people from the private domain, maybe with domain knowledge of the area which is being the subject matter of the regulatory statute, to relook at all existing statutes, just as the government has dealt extensively with repealing, the old and archaic laws which were no longer necessary in today's India. The next step would be to look at the language used in all statutes and then replace that language by recruiting domain experts in that field. Say it's a statute dealing with child rights, to have people from child rights, experts from child rights domains, and give them this task of replacing the language of the statutes and make it simple to understand. That's the second, the legislative drafting. The third, I think, contracts tends to be a little more complex because there's an infinite variety of contracts, from the electronic contracts to insurance to consumer. But I think, again, there, what could be done is that under the auspices of, say, the Ministry of Consumer Affairs, for instance, and civil society organizations like yours, pick up the leading contracts, insurance, banking, telephone, cell phones, internet service providers, and redefine these contracts. And I try to do that, in the example which I gave you for the apartment buyer agreements. Develop templates and then try and get the state governments to ensure that these are enforced, because India is a complex federal structure. It's easier for us to sort of find, sort of all the faults in the system, and much more difficult to answer how do we answer this? So I would think, to answer your question in one sentence, we need to operate and begin the initiative on multiple fronts: the judicial, the legislative, and the drafting of contracts.
No, I think that's a really concrete steps forward. And we have a large audience of students. Before we come to them, Gautam, since I cut you off on your third bucket, I'll just take that point to you, which is that a point that Justice Chandrachud also made, which is that the government seems to be aware of this and has redrafted the Income Tax Act, which is perhaps a real legal minefield, into a fairly simple version. So how do we kick on from here to try and make sure that this is not a one-off
Well, a
exercise?
couple of things. One is that I think we have to get within the legal fraternity, it has to be driven by consumers, and we really have to get rid of bad habits. Bad habits. We had a time when our conveyances in Bombay had to be on green foolscap paper, a paper size that does not any longer fit in a printer known to mankind. Why green? It's all digitized anyway. But the language is still the same. It's pages and pages without a full stop. You're buying a plot of land and it'll talk of rivulets and streams and to pass and repass with or without horses, without carriages. Stuff like this. These are just bad habits. England has actually done it. Your conveyance documents are short, title passes. Loan agreements, housing society loan agreements are 2.5 pages, so you know exactly what you're getting into. These are just bad habits that we have to get rid of. I don't know whether we'll be able to do this, but we have to do this sectorally. Take insurance, take banking. All of us need banks. All of us need some level of insurance. And routine legal documentation that you're going to need anyway. Powers of attorney, leave and license agreements. Leave and license agreements typically in Mumbai, I don't know what the practice is in Delhi, are just filled with pages and pages and pages of rubbish. I mean, really, representations, warranties, and this just goes on and on forever. And we are forgetting that we have before us actually models of very good drafting. I think Justice Chandrachud will agree with me. A model of very complex but very precise drafting is our Constitution. From the preamble onwards, Part 3 particularly, Article 14 is just beautiful in its short 2 sentences and the wallop that it packs into that. Similarly, for the preamble of it, these are examples of complex ideas being packed into very few, very precise words. That's all that we need to do. So there's no ambiguity about it. We've all had cases like this. A difference between a newborn and an infant. I don't know. Apparently. So.
The two areas where India has really made remarkable progress in the last, say, decade or so, which has been noticed globally. The first is the reforms in the real estate sector, unlike China, where the real estate sector has held them back, and the banking sector by the reforms and legislation which we brought about. Now, the real problem insofar as a real estate sector is the opacity of land records, because to search a title is a nightmare in India. So in the effort, the governments have already started working on this by bringing in digitization of land records and things like that. But if we have to really take it to the next level, I think land records and therefore conveyancing that Gautam mentioned is of critical importance. Secondly, banking documents. The third area which I want to emphasize is not just a question of, complex language, which is not easy to understand. A key area which has caused grave disquiet to me is the disruption of the family structures in our society, surely by the family courts not being able to dispose of cases. So that, if you have a marital dispute at the age of 27 or 28, people don't see the end of the road until they are 40 or 45. So imagine the life of the couple is gone. Now, part of the reason for it is just the way things are drafted. You have endless repetition of templates in proceedings, the same language, making vile allegations against each other, as opposed to, making simplified statements of fact to elicit the grant of final relief. So this is not just a matter of, making the law simpler to understand, but this has a very deep-rooted social impact on structures such as the family. And this is a matter of concern because just as India is becoming more mobile, wife in Silicon Valley, the husband in Bangalore, or the usual situation, and then distance breeds, other disputes. We're not able to settle family disputes. And the reason for this is the complexity of legal language. So it's having a big impact on our social structure. So there's a very great and urgent need for remedying this, and therefore the SARAL initiative is really welcome.
Oh, thank you. Yeah, sure.
I also think that we need to, we need to include this in a curriculum at some point in legal training about how to be precise about drafting. I mean, let me take this example about family courts, and it is an ongoing tragedy. But the pleadings that you see typically stereotyped, repeated, are not just absurd, they're demeaning. You cannot, I mean, typically a petition will start with on or about, is there any doubt about the date of marriage? Did you forget? Where is the on or about? Where does the about come into it? You have petitions that we've seen where the man is referred to at that time as a bachelor and the woman is referred to as a spinster. Why do you need to do this? And then we are told that there are two issues. Would you refer to your children as issues? Born out of the set, but not out of, from. And then it says wedlock. I mean, who talks like this? Why do you need to put things like this? This is going to lead to fuzziness in thought, in lack of clarity, and ultimately some level of injustice. This needs to be trained. Don't copy paste from what has gone before. It's time to break ground. It's time to break free of all this clutter. That's the only way, and it has to be consumer driven.
Right.
I'm the petitioner. I must understand what I'm signing.
Right, and I think that's very key, that it's not a laughing matter. There are real issues of justice that are involved here. And on the point of the rent agreement, you'll find that on your seats there were some pamphlets which has the QR code for our report. You'll also find the QR codes outside. Our report has a simplified version of a rental agreement where we've tried to say that this should be what a simple rent agreement looks like. Because as we've heard from this discussion today, language matters. We have we have a great audience here. We also have students from across the country joining us online, and we are delighted that we'll be able to take a few questions from the audience. Please keep your questions short and identify yourselves, and we'll also try and get one or two questions from those who are joining us online as well. Do we have a couple of mics? So we'll maybe take 3 questions together, and I'm going to try to be as fair as possible. This boy here has been sitting from 5 o'clock. This in the black blazer. So I'm going to go to him first. Then I'm going to come to this lady here, and then to you, sir.
Hello, am I audible?
Yes, just introduce yourself. Keep it a
Hi,
little
good
brief so that
yeah.
we can take as
Good
many
evening.
as
I
possible.
am Shivang. I'm a student at National Law University, Bombay. I'm in my 4th year. My question is to Honorable Justice Chandrachud. Sir, during your tenure as a Chief Justice, you had taken the initiative of translating the Supreme Court judgments into regional languages. Do you think the same can be done at the High Court level, and the High Court should follow suit? And can we employ technology in bringing the change?
So we'll take a few questions together just so that we can take a few more. Yeah, just pass it here. Yes.
Hello, sir. My name is Shreya, and I'm a student of journalism. I wanted to ask you this question. So you should know this beforehand. I'm a journalist, so I'm asking you from that point of view. You recently gave an interview to BBC, and there was a mention that the court system in India, and you somewhere represent that as well. The journalist has said that there is a dominance of upper caste, upper class male. When you answered the question, you talked about that there are more
You have a
women.
question on SARAL? Just
It's
yeah, just
simply
relate it
that I'm
quickly.
just
Yeah.
that there are more women entering the field. I want to understand from you, one, how would you answer that question differently today, to the point that, as you mentioned, majority of the Indians do not have the access to the English language the way people like you and me living and sitting in Delhi do. So how would SARAL and other measures help in making sure that that the court system in the country becomes less upper caste and upper class?
Thanks. Just in front here. Yes. Yes. So she will translate it. Can you? Yes.
So I'm a deaf person. In 1947 till this year, 2025, thank you so much. I think that this is the first platform, the legal platform. We have the sign language interpreters. One request I would like to make: whenever there is a deaf person who is being acquitted, okay. So, for example, when we send someone to witness, okay, in section 61 and 244, so they were not provided with the interpreter. What happened, that the one interpreter came for the first time, then in the later on in the other hearings interpreter didn't come. What happens, then they didn't realize that whether it was fault of the interpreter was just translating, but the authorities, the courts thought that interpreter is a witness. So I think this should be clarified, that interpreter is not a witness, they are just translating. And also about the QR code, whenever you are, making any reports, anything, it should be translated in Indian Sign Language for the deaf community so that they can access the reports, okay? And that's how, you can make the accessible, the courts and the legal proceedings. But since 1947, I think I haven't seen any platform where we have the interpreter, but I'm so great here that we have the.
Thank you so much. Sir.
Thank you. I'll answer all the three questions. The first question on the translation of judgments of the Supreme Court from English into all the regional languages, which is incidentally taking place using AI-assisted software. We've used the Bhashini software of the Government of India and Suvas, which is a software which has been developed specifically for the Supreme Court. Your question was, what about the High Courts? In fact, I constituted a committee chaired by Justice Abayok, and the committee is specifically engaging with the High Courts so that what initiative has been taken by the Supreme Court of translating judgments of the court into regional languages is also pursued by the High Courts, and that process is already underway. What's the purpose of this? It's also part of the SARAL initiative in the sense of making the law, the judgments, comprehensible to the people for whom it is meant, right? So that is to promote access, comprehensibility, and the association of citizens with the judicial process. That's the first question. Insofar as the second question is concerned, you have to also accept that if you watch the BBC interview, I mean, this is not a complaint at all. The time for answers is limited because you have the person who is asking the questions also speaking quite a bit. So the amount of time that is given for an answer is also comparatively limited because everything had to be done within the space of 25 minutes. But I can tell you what I couldn't say there, not because I thought of it later, but you're completely short of time, which is to postulate that the Indian judiciary is predominantly male, upper caste, is, I think, contrary to reality. First, at the base of the pyramid, something which I mentioned, in most states where recruitment is taken to the district judiciary, more than 50% of the recruits are women. And that's the status of the legal education in general. More and more women now are entering into the law schools. You look at the national law schools, you'll find that over 50% of the new students who are admitted are women. And that's what's happening at the lowest level. Insofar as the Supreme Court is concerned, you will find that, well, we had a retirement, but otherwise we had 3 women judges. We have 3 judges belonging to the scheduled caste. They've not been appointed because they belong to the scheduled caste. Let me be very, very clear. They're appointed because they are excellent judges. We do not have a specific quota. But nonetheless, in the interest of promoting diversity, we have, one of them has just retired in January, but we had until January 3 scheduled caste judges. There's diversity in terms of religion as well. You have judges drawn from the Muslim community, a Zoroastrian, a Christian, so on and so forth. Again, this is not something that we statistically represent as to how many OBC judges you have. But this is something which is done and taken up on an active basis. But again, making your point really is very important because the way you linked it up with the SARAL initiative was this, that if we promote access to the law to people in regional languages, in languages which they understand and speak at home, we'd allow for a more broad and diverse representation in the judiciary, because all said and done, English has a certain cultural capital associated with it. And how do you then account for making the profession and therefore responsible constitutional offices more broad and diverse, which is to address this basic cultural deficit, you know? And the best way to do that is to ensure that we encourage and facilitate legal education in regional languages. We hold the CLAT, the Common Law and Aptitude Test, only in English. That's the first part which has to go. Second, there has to be state governments have to encourage setting up more and more legal educational institutions in the local language of the state, be it Hindi or any other language, which would ensure that students who are bright but who cannot appear for entrance examinations in English will be able to compete. They are the people who will be able to, go to the district courts. That will ultimately facilitate the cause of greater diversity. So language in that sense, as Argo just mentioned a short while ago, it's not just about simplification of language. That's the point which I tried to make in the course of my address. It's also, besides just the simplification of language, there's a whole social issue which is at work here, which simplification would entail in terms of just access to justice and access to legal education, and therefore bringing greater diversity into the legal profession. So far as the third question was concerned, I think you made several points, actually, more than a question as such. And each of the points which you made is absolutely valid. I think what we need to do is to bring about a national protocol for all of these issues pertaining to reasonable accommodation for persons with disabilities. So it shouldn't be left to individual courts to, for instance, have a sign language interpreter when you have an individual lawyer who brings it to the notice of the presiding judge in the court. We must have a national protocol. The Supreme Court tried to do this by having an accessibility audit of its premises. And then I've written to Chief Justice of all the high courts, asking them to have an accessibility audit of all their premises so that we can have a national uniformity in terms of the basic minimum facilities which must be provided by all courts in India to promote access to justice.
Thank you very much. We'll take 3 questions now from this side because we've done this side. There's a girl at the back. If you could just go to her. We'll take one from here and one from there. Yeah.
Good evening, everyone. Thank you for the opportunity. My question is to Honorable Justice Patel. Since he mentioned it in his argument that it is important to train law students, especially in pleadings, because it gets very difficult. However, the question is that since we, the young generation, has the power to bring a change, how can we practically contribute as law students to make law actually SARAL? Thank you.
Now we'll go to here. Yeah, in front.
Take this one. All right. So I'll try to be brief. Now, Justice Chandrachud, you said that one might deliberately make legal language complicated because you might want to have an upper edge over the party that doesn't have resources, that doesn't have adequate resources, maybe to fight that particular case. Now, I'm using an example here where people have said that the said law that was really comprehensive and it has been made very concise, it has had a detrimental effect. Now, I'm talking about sedition in IPC, changed to BNS. Now, the BNS thing states that the new offense for acts endangering the sovereignty, unity, and integrity of India. Now, I'm not going to go into this normative or the philosophical aspect of this or the merits, but do you think that there is a need to balance the laws because you have to avoid loopholes? When the laws are short, there might be even loopholes that that can be exercised.
Fair point, and it's a good
versus
example.
the comprehensive laws that prevent the access of prevent the cause of justice to be.
Thanks very much. We'll just go there and then we'll go online for one question.
नमस्ते सर, मैं राजस्थान के पश्चिमी राजस्थान के एक पोखरण कस्बे का रहने वाला विद्यार्थी हूं। मैं वर्तमान में दिल्ली विश्वविद्यालय में हिंदू कॉलेज में 3rd ईयर में अध्ययनरत हूँ। मेरा आपसे सवाल हिंदी में पूछने का एक कारण है, क्योंकि मैं जिस क्षेत्र से आता हूँ वहाँ पे इसी भाषा के अभाव के कारण लोगों को, आम जनता तक न्याय नहीं पहुंचता। गांव में, पिछड़े गांव में पहुंचे लोगों को जानकारी भी नहीं है कि देश की न्याय व्यवस्था किस तरीके से काम करती है, और उन्हें इस भाषा के सिर्फ अभाव के कारण वो अपना जीवन विभिन्न चुनौतियों में गुजार देते हैं। वो किसी भी लीगल इंस्टीट्यूट के पास पहुंच ही नहीं पाते हैं, उनको वो माध्यम ही प्राप्त नहीं हो पाता। और वहां पे जैसे हमारे नजदीक हाई कोर्ट इंडिया राजस्थान का देखें तो वो जोधपुर है, लेकिन उस पूरे क्षेत्र में ऐसे वकीलों की भी कमी है जो अच्छे से मतलब किसी भी मुद्दे को उठा पाए, या आम जनता जो अच्छे वकील है उनकी फीसेस बहुत ज्यादा है तो उनके पास पहुंच नहीं पाते, और इस बाधा, सिर्फ भाषा की बाधा के कारण वो न्याय प्राप्त नहीं कर पाते हैं। तो आपको क्या लगता है कि हम, जैसे मैं इस दिल्ली विश्वविद्यालय जैसे प्रतिष्ठित विश्वविद्यालय का छात्र हूँ, तो हम लोग कैसे, वहां की आम जनता किस प्रकार से इसको अच्छे से कर सकती है जो आम अंतिम पंक्ति तक बैठे व्यक्ति के पास न्याय पहुंच पाए?
So just for Julie, who may not have followed the question, he's from Western Rajasthan and he was asking that language is a great barrier to accessing justice because a lot of people don't speak English. And so, how is it that we can overcome this barrier? I'm paraphrasing here, but how is it that we can overcome this barrier of language to ensure that justice goes to the last person? We have students from across the country, so I'm in the position to take only one. So we have Ashlesha Pandey from Raipur. So Ashlesha, if you could please put your question.
Thank you, sir. Good evening, panelists. I am Ashlesha Pandey. I'm the convener of Kautilya Society at NLU. And my question is pretty straightforward. Now, with the rise of legal technology, do you think that technology can be leveraged to aid simplifying legal documents specifically for citizens? And if so, what role should the government and legal institutions play in regulating these innovations? Thank you.
Thanks very much. Maybe we'll get Julie to answer that first question, the last question on technology and what role you think technology can play in simplification. And then we'll come to the panelists for a last word from each of them. Julie, please.
I think technology can play a big role as long as we don't rely too much on it and just presume that it is making all of the right decisions for us. As the Chief Justice, I believe, pointed out, AI will tell you what you probably want to say, and then we all start to talk, speak together. One of the big problems with AI in legal work is that often people will produce, I'm seeing this over and over, people will produce briefs and draft opinions even, unfortunately, that were written by AI, and they have incorrect law. They have citations to authority that doesn't exist. So we have to be really careful about it, and we have to help drive those changes and those improvements so that technology works for us instead of us working for technology. I think the same thing goes to the question before, and that is technology can help us with those language barriers. Today, if you were all speaking not English, I wouldn't understand anything, and I would be the odd person out. But technology can sometimes help that. Whoever is, there are always people who can't understand, even if it's the same language. If we're all speaking legalese, there are people who won't understand. So technology can help all of that.
Thanks very much, Julie. Mr. Sagar, do you want to take that question on loopholes and why there is a need for what the boy in front asked, that maybe if we sometimes make it too concise, there will be too many loopholes?
Well, I don't think so. I think simpler and plainer language is not an antithesis to good law, for that matter. So I wanted to just, actually, if this is the last chance I have, I wanted to just make a couple of comments. Arge, this is okay?
Yes, please.
So one is that I like that the expression that the Chief Justice used to say that language that you speak at home. So I was actually reminded of this instance, an anecdote happened about 10 years back when I had a youngster who came in from another law firm, had been in practice for about 4 or 5 years. And I asked him to write up something. He came back with a 3-paragraph memo, which was actually in every paragraph, there were at least 4 or 5 or more Latin words that were used. So I called this young man in and I said, I have a question to ask you. It's a personal question. I hope you won't mind. So he says, no, sir, go ahead. I said, do you speak Latin at home? So he was a little surprised. So I said, look, okay, let's do one thing. Let's see where can we are sitting in Delhi. Where is the closest where there is a school which will give you a certificate for Latin language? And we trawled the net and we found a place in southern Italy, which was 4,900 miles away. So I sort of said, look, but why are you using this? And that brings to the point of old habits die hard. And he tells me, he says, my previous senior actually said that you must use Latin because that's a sign of being scholarly, that's a sign of being learned, and the client will really be impressed by it. So I said, well, look, are you here to impress the client with something that he doesn't understand? Or you are here to answer the question that the client asked? So I think, again, it comes back to that for lawyers as well, for us to say, we use, grand words, we use this lot of words. We put them together in a very difficult way, making it difficult for the reader. It's long sentences, and as Gautam was saying, full stops are free. You don't have to pay for them, period. They're free, they're free to be used, and you should use as much of those as you want. Liberally use them, and not making your writing stilted by, having sentence with 3 words, but, I think use them liberally. So, yeah. So, yeah.
Okay. If you want to say something more about this.
No, I mean, we talked about communicating law, and we talked about what happens in areas where English is not understood that well. And actually, that's where it comes in, because if you have simple, plain language, even in English, because English does remain the language of the superior courts, and that's where the law is laid down in that language, right? And therefore, I sometimes worry when I read some paragraphs and some judgments where you can't understand anything. And I think I have fairly good knowledge of the English language, and I worry about a lawyer sitting in a Bhagalpur or a Raigarh or a small Mufassil court in Tamil Nadu or Odisha, who's trying to explain to his client what the law is. And I was particularly, for example, I use it in my training programs, is the opening paragraph of a judgment which was rendered by our Supreme Court by the then Chief Justice. And the opening paragraph had 2 sentences. The total number of words in the opening paragraph were 299. The first sentence was 73 words. And the second sentence was 226 words.
It was not his.
It wasn't yours, okay? And we actually used that as an exercise. I was conducting a program at the Brij Mohan Munjal University. And along with the students, we brought that thing down as to what the honorable judge was trying to say into 36 words in 3 sentences. And I was just thinking to myself about the writer. I said, you made it to the top. Now, whom are you trying to impress? You have no further prospects,
I think just in the interest of time, we'll move on. So Gautam, there was that question for you, and our mentor, someone who helped us put the private documents together, Siddharth Raja, also had a question for you, which is that how do we try and get to this simplicity when lawyers are usually risk averse and don't want to change, and then we'll leave that at the end.
So as far as the students are concerned, sorry, what was Siddharth's question?
That how do we move lawyers away from this kind of complexity when they are so precedent bound?
Well, one of the things is that the client must start demanding simplicity and clarity if the client is signing the document. Corporate clients in particular, and you can't have an answer, I've hired a person to do that. If you're signing it, you should understand what is being done. And as far as students are concerned, my recommendation is read as widely as possible outside the law. It will teach you what you can do with language, how you can keep it compact, how you can keep it concise, and the things that are possible with words. Once you start doing this, you learn to say things with economy, with precision and concision, which are the things that you want in law, and get the idea across. Above all, I keep telling students, I'm teaching a course in CPC now. At the moment, it's turned out to be much harder than I thought it would. Because of this. Precisely because of this, the Civil Procedure Code says that pleadings must be concise and must state material facts and not evidence. What have you understood by that? That's the problem. You have to teach, you have to understand what this means when you put pen to paper.
Supplement that just for a minute. I think this education piece is very interesting. There's no course or no, no emphasis on writing skills. Forget about legal writing skills. You need that in the curriculum, right? In the first or the second semester, so people can use those writing skills for the rest of the program, and then they become good writers. So today you have conveyancing, which is, I think, usually in the 5th semester. And what are you supposed to do in conveyancing? You mug up a lease deed and you vomit it on your paper in the examination. And then they don't teach you tips and techniques of how to draft, how to use the language. We are, after all, wordsmiths. That's what we are, lawyers. I mean, articulation, whether it's speaking or writing, is 80% of the time we spend on that. But nobody teaches us. It's like having a plumber who doesn't know how to use a wrench.
Julie, a very quick follow-up, and then we'll end with Justice Chandrachud.
Thank you very much. I just wanted to comment
Sorry,
on
we
that.
can't hear you. I think you're still on mute.
I am still on mute?
No, we can hear you now.
Okay, good. I just wanted to comment on that because in my law school, my law professor was Joseph Kimball, who is an internationally known plain language expert. He's in your, you've cited him in your report. And we started, and then I taught in that law school. We taught plain language legal writing throughout. And what I found when I got out was that there is still so much pressure from the legal community, and new lawyers want to fit in, that they automatically forget what they've learned, even if they learned plain language legal writing and legal drafting. So it's really unfortunate. It has to be, a holistic change that the senior lawyers have to be pushing this as well.
Thank you. So the last word to you, Justice Chandrachud.
मैं आपके सवाल का जवाब देता हूँ. देखिए, भाषा और न्याय प्रणाली का जो संबंध है वो बहुत नज़दीकी संबंध है और निकटतम मैं समझता हूँ संबंध है, क्योंकि भाषा केवल एक माध्यम नहीं है, पर भाषा से हम न्याय पहुंचा सकते हैं. अब सबसे महत्वपूर्ण चीज़ जो बदलाव लाना है हम लोगों को, वो इस बात में है कि आज देश भर में कानूनी शिक्षा जो है वो क्षेत्रीय भाषाओं में नहीं होती है, कहीं पर भी नहीं है. तो इसकी वजह से इससे जो दो प्रॉब्लम्स पैदा हो सकती हैं. एक तो यह है कि जो उस क्षेत्र में लोगों के लिए काम करना चाहते हैं उनको आप कानूनी शिक्षा पढ़ा ही नहीं सकते. अब आज जरूरी है कि हर एक राज्य में, खासतौर पे राज्य सरकारों ने अपने क्षेत्र में, अपने राज्य में जो भाषा लागू है उसमें कानूनी शिक्षा करने की जरूरत है. अब हमने जब सुप्रीम कोर्ट के जजमेंट्स का सीधा अनुवाद किया सारे भारतीय राज्य भाषाओं में, उसका कारण ये था कि कम से कम हम, आज तो किताबें नहीं हैं पढ़ाने के लिए, पर कम से कम ये जो सुप्रीम कोर्ट के निर्णय हैं, कम से कम वो तो अपने क्षेत्रीय भाषा में हम लोगों को दें, ताकि उससे भाषा में कानूनी शिक्षा हम कर सकते हैं. अब इसकी ज़रूरत है, क्योंकि जब तक हम उस क्षेत्र में वकीलों को तैयार नहीं करें, वो, अब मान लीजिए एक तमिलनाडु में एक कृषि का सवाल पैदा होता है, किसान है, अब उसको आप अंग्रेजी में कौन पढ़ाएगा? ना ही जो काम करता है उनके लिए वो अंग्रेजी जानता है, ना ही जिसके लिए हम काम कर रहे हैं वो अंग्रेजी जानते हैं. तो जब तक हम भाषा, क्षेत्रीय भाषाओं में, राज्य की भाषाओं में कानूनी शिक्षा नहीं दे देंगे, इस प्रणाली को हम बदल नहीं पाएंगे. तो मैं समझता हूँ उसमें बहुत ज़रूरत है, पहली ये बात है. और ये जो अनुवाद किया हमने सुप्रीम कोर्ट के निर्णयों का, हमने सोचा कि ताकि मान लीजिए अब कोई उड़ीसा की इशू है, तो आप जब उड़िया में जजमेंट्स प्रोवाइड करते हैं तो पुलिस स्टेशन में या सब डिविजनल मैजिस्ट्रेट्स को ये जजमेंट चली जाती है कि आपके जो लैंड रेवेन्यू रिकॉर्ड्स हैं उसमें ये प्रणाली आपको अपनाना चाहिए, या पुलिस को कोई उसमें डायरेक्शन है जैसे एफआईआर के बारे में, प्रिलिमिनरी इंक्वायरी के बारे में, ताकि उनको भी समझ लेना ये केवल नागरिकों का ही सवाल नहीं है, पर बाकी जो सरकारी प्रणाली है जैसे आपके एसडीएम्स हैं, कलेक्टर्स हैं, स्टेशन हाउस ऑफिसर्स है, इन्वेस्टिगेटिंग ऑफिसर्स है, उनकी भाषा तो अंग्रेजी नहीं है। तो मैं समझता हूँ बहुत महत्व इस पे देना चाहिए। सरलता केवल अंग्रेजी भाषा की नहीं है, पर सरलता हमारी राजकीय भाषाओं में आनी चाहिए, ताकि आप उसी भाषा में कानूनी शिक्षा दें जो हमारी हर रोज की बोली है। अक्सर हम देखते हैं कि जो राजकीय भाषा है, जैसे मेरी मातृभाषा मराठी है, जो हम घर में मराठी बोलते हैं, और जो सरकारी मराठी भाषा है उसमें बहुत विपरीत है, बहुत दूरी है, उसको भी मिटाने की ज़रूरत है। तो जब ये हम करेंगे तो मुझे लगता है, और बहुत बहुत कठिन नहीं है ये काम, राज्य सरकारों को करना चाहिए। आज प्राइवेट इंस्टीट्यूशंस आई हैं, उन्होंने राज्य की भाषा में कानूनी शिक्षा देने की ज़रूरत है। और ये जो सरल का प्रोजेक्ट है, इसलिए अभी जस पटेल ने मुझे कहा और को भी मैंने कहा कि ये केवल अंग्रेजी भाषा का प्रोजेक्ट नहीं है, दिस अ मल्टी लैंग्वेज प्रोजेक्ट। हर एक भाषा में इसको हम अपना सकते हैं।
So I think that's just later. So that's, I think, both a positive note as well as a sobering note to end on, that we know that language can be a barrier. And in India, the English language itself is a barrier. So it's not just about complexity, it's also about the choice of language. At SARAL, we are trying to make it as multilingual as possible. There's a lot of plain language drafts in Hindi. And as he was saying, that to do a legal version of a document in Hindi is actually very hard, because what is official Hindi is again not SARAL at all. I mean, we all know that, apatkalin dwar in the aeroplanes, as in no one knows what that means. But I think there is a lot of work here that needs to be done, and it can only be done if there is a movement that builds. And the world over, plain language has happened through a citizen consumer movement. And I think citizens have to demand simplicity, and then simplicity will follow in some period of time. So I'm really delighted that all of you have turned up today in such large numbers on this issue of simplification. It may have less to do with simplification and more to do with Chief Justice Chandrachud, but be that as it may, I'm really delighted that all of you could be here. A special thanks to our panel, Julie Clement, who's joining us this morning from Michigan. Thank you very much, Julie, for joining us today. There'll be a small token of our appreciation which will find its way to you. It's currently being FedExed across, so hopefully it will reach you soon. We'd also like to thank a small token of our appreciation from our team to Mr. Jyoti Sagar. Thank you, sir, for being so inspiring and for supporting this initiative right from the get-go, because surveys cost money, and Mr. Sagar has very kindly supported this initiative from the get-go. So thank you very much, Mr. Sagar. To Justice Gautam Patel, who's always been there for us and really been batting for SARAL in a way in which very few have. So thank you very much, Justice Patel. And last but certainly not the least, former Chief Justice of India, Justice Chandrachud. Thank you so much, sir. Thank you so much for coming. This really means a lot. And it's a great fillip for all of us to have you here today. And last, thank you very much, ladies and gentlemen, for coming today. Once again, the report copies are available online. We should have a few physical copies as well outside. So do please pick them up and join the SARAL movement. Thank you very much. A very good night.